let's discuss the Child Protection and Obscenity Enforcement Act of 1988. If you remember in Ferber, one of the findings of the U.S. Supreme Court was that authorities needed to attack the network of child producers and child pornographers. And with this in mind, the 1988 Act adds a second level of pornographer. The first level, the Act identifies them as primary producers. And a primary producer is somebody who is in the business of creating sexually explicit material, which is not against the law. However, to control who is being used in this industry, in terms of the actors, if you will, these companies must keep on record a great deal of information concerning the individuals who are involved in the films as actors. And what the authorities are allowed to do is come in and review those records, which must be maintained by the companies. And they review those records and they are analyzing them for anyone who may be in the production who was under the age of 16. So these registries can either be at a state or federal level, but they must occur. It is really a matter of extensive record keeping as I read the legislation, and these records must be made available to the prosecutorial staff either by notice or no notice needs to be given. If these records are not provided, it is a penalty of no more than 10 years in a federal prison. However, more interestingly to me, and what relates to child pornography, is Congress realized that there were a significant number of people out there who were skipping the laws, if you will, because they were not considered to be primary producers. So this act creates a second level, and that is the secondary producer. And the secondary producer, as I read it, seems to me to be people who are more users and at the very, very low end of the sexual pornography industry, if in there at all. Again, to me, they are more of the users as opposed to the producers. But Congress does define a secondary producer. And this is one who duplicates, who produces, assembles, manufactures in any way, publishes, or reproduces any films, any books, or any videos, or excuse me, or creates any other matter of child pornography that is intended for commercial use. And also there is an enforcement penalty for the secondary producers, and if they do not have the material that is required to be kept on record, then they can be sentenced for 1 to up to 10 years. This is an indeterminate sentencing. And I know if you're sitting there, you're thinking, well, how does that all occur? Well, I want you to think of it as a sentence enhancement. So, for example, a federal prosecutor busts somebody for child pornography. And then that is a crime in itself. But then they say, okay, where are your records of those children, those actors that were involved in your production? And of course, you're going to look at them and say, what are you talking about? Well, under this law, I'm talking about another 5 years onto your sentence. And so this is a means of creating what I said is sentencing enhancement, and the federal courts can then put people behind bars for a longer period of time using these kind of acts. So with that, I'd like to move on to the Adam Walsh Act of 2006.